Let's get started. Good evening, ladies and gentlemen. This is Chris Carley, Chairman of the Concord Zoning Board of Adjustment. Welcome to the November meeting of the board. Due to the COVID-19 coronavirus crisis, we will be conducting our meeting electronically rather than in person, as authorized by Governor Sununu's Emergency Order Number 12, pursuant to Executive Order 2020-04. The Governor's emergency order waives the usual legal requirement for a physical location at which the public can observe and listen contemporaneously to ZBA meetings. However, in accordance with the emergency order, the city is taking the following steps to provide for public participation in and access to the proceedings as fully as possible. On the requirement to provide public access to the meeting by telephone, with additional access possibilities by video or other electronic means, we are using the Zoom platform for this electronic meeting. All members of the board have the ability to communicate contemporaneously during the meeting through the Zoom platform, and the public has access to contemporaneously listen and, if necessary, participate in the meeting through dialing the following phone number: 1-929-205-6099. I repeat, that's 929-205-6099, and the password is webinar ID number 610-919-318. That's 610-919-318. Or by clicking on the following website address: us02web.zoom.us/j/6109-19318. We are also providing public notice of the necessary information for accessing the meeting. The city has given notice to the public of how to access the meeting using Zoom, and you can find detailed instructions on how to participate on its website at concordnh.gov/280, that's 280/zoning-board-of-adjustment. We are providing a mechanism for the public to alert the public body during the meeting if there are problems with access. If anybody has a problem, please call 603-856-3913 or email at code@concordnh.gov. We will adjourn the meeting if the public is unable to access it. In the event that any member of the public is unable to access the meeting concerning a case or cases in which they have interest, please call 856-3913 or email code@concordnh.gov as soon as possible. We will adjourn the hearing and reschedule it for a time that will allow all to participate. Please note that all votes are taken during this meeting shall be done by roll call vote. Let's start the meeting by taking a roll call of each of attendance. When each member states their presence, please also state whether there is anyone in the room with you during this meeting, which is required under the right to know law. Mr. Wallner.
Nicholas Wallner. I'm in my home office and I am alone.
Mr. Monahan.
James Monahan. I am in my home office and I am alone.
Ms. Spector Morgan.
Laura Spector Morgan. I'm in my home office and I am alone.
Mr. Winters.
Andrew Winters. I'm in my office. I am alone.
I'm Chris Carley. I'm also in my home office and I am also alone. We will be following our usual procedure this evening, which is to say we will take the cases in the order in which they appear on the agenda. We do have one case this evening which is on the agenda but is not going to be heard this evening. And that case is number 56-20, Family Promise of Greater Concord for 95 Loudon Road, LLC. That hearing will not be held this evening, so if you're tuned in for that hearing, you need not stay with us. We will, as I said, follow our usual procedure. All the other cases on the agenda will be heard by a full 5-member board. I assume that's true, correct? Are you there, Craig?
Yes, that is correct.
Okay. We will ask the appellant to identify themselves. I'll swear them in, and we'll ask them to give us any information that they believe bears on their case and supports their appeal. we ask them, if at all possible, to confine their presentation to 10 minutes or less. We will then solicit testimony from anyone who is opposed to the request for the appeal, and also from anyone who is in favor for of the appeal. Again, those people should signify by raising their hands, and we will call on them, swear them in, ask them to present whatever information they would like us to know. We request that they confine their testimony to 5 minutes or less, again, if at all possible. Normally, the board will consider each case and act on it prior to moving on to the next case. Our first case this evening is a recessed case from last month's hearing, 4120 Fred L. Potter. Do I hear a motion to take the case, open the case?
So moved.
Is there a second?
I'll second.
All in favor?
Aye.
Vote is unanimous. The case is brought up for discussion. My recollection
Carly?
is,
Please make sure you do a roll call vote.
yes. Oh, I'm sorry. Okay. Mr. Wallner,
Nick Wallner, aye.
Mr. Monahan,
Aye.
Ms. Inspector Morgan,
Aye.
Mr. Andrew Witters,
Aye.
and I, Chris Carly, also vote aye. Am I back out of the doghouse, Rose?
Absolutely.
Okay.
Good job.
My recollection is in the case of 4120, we heard the case. We were actually in the stage of deliberations, if I remember correctly. And we requested at that time that the case be recessed so that we could hear testimony from city officials on the subject of the placement of a placement of a sign within a certain distance from a corner where there's a stop sign. Since then, my understanding is that Mr. Potter has amended his application and changed the shape of things a bit. Mr. Potter, would you like to fill us in on the details of that?
Yes, I would, if I may, and I'd like to start. Are you able to hear me? Okay? Are you able to hear me?
Yes, may I swear you in?
Oh, I'm sorry. Yes.
You swear to tell the truth?
Yes.
And identify yourself for the record, if you would.
Fred Potter, live at 4 Pond Place Lane in Concord, and we're here today with respect to property we own at 135 North State Street, Concord, New Hampshire, on the same block as other property we own at 125 North State Street. The 135 is, of course, at the corner of Church and State Street, and 125 is at the corner of Franklin and State Street. I'm assuming we don't need to go. The board heard the background on the hardship. I will mention one item only because this becomes dramatically more simple and hopefully save the board some time. First, I'd like to apologize. I think part of this is a hazard of the COVID-19. Craig Walker and I have been pretty effective at limiting issues, and this just came to you with a basket full of stuff, and we do not need all these variances. We're down now just to the variance for 4. The other questions arose, I think, in part because of the presentation materials, which superimposed a picture of the sign on the front of a bush that was located near the corner. There was never any intent to locate the sign right there. The bush has since been removed, and in order to help our city council representative and some of the neighbors, we actually planted a temporary for lease sign exactly where the intended location is, which is outside of the restricted area. Thank you, Craig. And I think she took that picture today, as a matter of fact. And we made a sign of the size that's intended. So the materials we had filed suggested we were right up against the wall in the corner. The bush, which did obstruct the view, has been removed and actually moved to shield some of the view of the HVAC farm that's at the corner of the renovated building now. So we are requesting only relief on item 4. We did hear the comments. I had asked Advantage Sign to design this sign to be similar, so it bookended the block, similar to the 125 North State Street. We did hear the concerns of the board and some of the neighbors. that a sign of the same size as what we had on the other corner felt a little too large. And so we reduced it to 20 square feet so that it does not require a variance for size. Also, Craig was helpful to me. As I said, I really didn't quite understand why we had all these variances because I did not view these as two signs. One was an address marker to help with movement of traffic, and Craig advised me that were I to remove a tagline which looked like marketing and just leave the logo and the address and reduce to 4 square feet, which was allowed for markers, that would not be a sign for the purposes of this ordinance and therefore does not need to be considered with the other. So we have refiled, and as you may recall, I offered at the meeting to remove one of the slats to get us below the 20 square feet, and indeed we have done that, and we are below the 20 square feet. So I apologize for taking some of your time needlessly. With respect to the hardship, I would simply mention, as you see, we have preserved a stone wall which has a 150-year history as part of this project. That wall varies in heights from 30 inches to 56 inches, and we are asking for an additional 14 inches above a normally allowed height in order to help us clear the stone wall. There also will be parking along North State Street between the roadway where people need to see the sign and the sign. That's another reason why we would like to lift it up just a little bit so it actually can be seen and won't be buried below the wall and the parked automobiles. So that's the update. We're asking only for what was formerly the variance number 4 to allow a height of 7.4 inches, mindful of this wall that runs between 30 and 56 inches in order to get us up above the wall. So we're asking for 14 inches to get up above the wall, which is 30 inches. The other thing is that the grade, as I mentioned before, slopes generally downward. So if you were traveling on the opposite side of State Street, it would be even more difficult to see the sign if we didn't lift it up just a bit. So we're requesting just one variance, and that's from the limitation of 6 feet to allow the top of the sign to be at 7.4 feet. That, for your reference, is over a foot shorter than the 125 North State Street sign at the opposite corner that has similar problems with blockages between the sign and the passageway on the road. So that's it, and I hope that makes the process a lot simpler, and I do apologize for taking your time, not having worked through some of these issues with Craig before the meeting. We simply didn't meet, and I think Craig was kind enough to help steer me in the right direction once he understood what we were trying to accomplish.
Very good, thank you. Questions from the board?
I have one question. Mr. Potter, does that mean you're no longer requesting a variance for the lamppost sign?
My understanding is it's not a sign. Under the ordinance, it's a marker. And I'm not sure I'm saying the words correctly, but correct. We're not requesting a variance because we understand no variance is required for that address marker to be there. And the primary purpose, as I mentioned, was to help separate from the newly installed pocket neighborhood. There's a lot of confusion around there, and to identify the building to which people will be coming as the Governor Center. So correct. I understand we do not need a variance, and we're not asking for it.
Thank you.
And just to clarify, yeah, it's a building marker sign identifying the building and showing the address. If they are allowed one per lot, so long as it's less than 4 square feet in area, and it does not require a permit, so therefore would not be considered a second freestanding sign on the property.
That is what we're asking for the height on, right?
No, we're asking for the height on the main sign at the corner. And we're asking for a height of 7.4 feet, the old number 4, instead of the prior 6 feet, instead of the allowed 6 feet.
And you need that additional height because of the height of the wall. You need to have the sign sort of up a little bit
Correct,
bottom of it so people can read it with the wall the way it is?
correct. The wall runs between 30 and 56 inches in height. So if you're limited to 60 inches, of course, you wouldn't be able to see the sign as you go along State Street.
Mr. Potter, I remember, I'm just trying to refresh my memory, and I was looking at the minutes, that there was a couple of objections from the neighbors, I think primarily having to do with blocking the stop sign and also from general services. So was that related to number 4, which is the height, or was that related to the size?
It was related to number 5 being in the 30-foot triangle. And
Okay, so
it wasn't intended to be where it appeared to be, but that doesn't matter. We had asked for it, and that was the objection, as I understand it. The location is no longer a variance request.
okay, and maybe I'm putting you in a fair position to characterize their objection, but I mean, I know you're honest about it. That to your understanding, that objection is now moot.
I think the location is, the city council person did go out. She actually took that picture, and I had actually put the temporary sign there at her request so she and the neighbors could see it. And I understand her communication today to mean that she's satisfied, and we haven't heard from anybody else about it. I believe they're satisfied.
Thank you.
Any other questions from the board? Thank you very much, Mr. Potter.
Thank you.
Given that there's been new information offered, I'm going to find out if there is anybody who would like to testify in favor or in opposition. Is there anyone who wishes to testify in favor of this appeal? Is there anyone who wishes to testify in opposition to it? Any other comments from code enforcement, Craig?
No, I don't have anything to add. You should have a couple of letters in your packet there to read into the record too, I believe.
I do. I have one here from Eileen Kime, who is owner of the property at 7 and 9 Bradley Street. In my opinion, the current sign ordinance is a wise one, allowing information while discouraging visual pollution and driver distraction. To me, these proposed signs are entirely too large and are not in keeping with the neighborhood and out of proportion to the permitted signs on North State Street and on feeder streets. Article 2867 would sensibly prohibit a sign with a height of 7'4" within a triangular area adjacent to a corner where such a sign might well constitute a serious hazard to traffic safety. I would oppose such a sign. I greatly fear that allowing the requested signs would not only create serious visual pollution, but would establish a dangerous precedent in an area where home businesses are allowed. Would an attorney be allowed such a sign? An accountant, a beauty salon? I wish you to stand firm on the present signage ordinance and not grant these exemption requests. And then the other note, which I think is the one that you're referring to, is from James Major. Is that correct, Greg?
Yes, that is. James Major.
I discussed, James Major is with the city of Concord.
Yes.
I discussed this with Chip, and General Services does not recommend moving the stop sign and street sign to accommodate the proposed sign at the corner. This was our position earlier this summer when this was discussed at development team. The stop sign is regulatory and it's where it's supposed to be, at the stop bar prior to the crosswalk. And that's all that Mr. Major had to offer. With that, we'll declare the public testimony portion of the hearing closed. We have an abbreviated version of 4120, as we heard it last week, a request for a height variance for a single sign, which would go near the corner of, is it Church Street?
Yes, that's corner Church and North State Street.
Church and North State Streets. And whereas before it was, they were proposing to put it within the no-go zone, they have moved it back, and so we're talking solely about height variance. We heard testimony that the height of the stone wall adjacent to the sign inhibits people's view of it, and they would like to make it a little bit higher than the ordinance permits. What do you think, Mr. Wallner?
Well, I think certainly the stone wall issue is what creates the unnecessary hardship. And I think it meets the rest of the criteria for a zoning variance.
Very good. Mr. Monahan?
I agree with Mr. Wall.
Inspector Morgan?
I agree as well.
Mr. Winters?
I was skeptical last time around. I think many of us, if not all of us, were because of, but in reviewing it, it had more to do with the placement of the sign in the triangular area and also with the size of the sign. But he actually doesn't need a size variance anymore because the sign, the other one's not counting as a sign. So I think the stone wall is legitimate, and the neighbors' concerns as well as the city's are addressed by the fact that he's moving the location.
Thank you. I also agree with my colleagues on the board. There does seem to be a hardship created by the peculiar nature of the lot, and I would support a motion to approve. Is there such a motion?
I will make that motion.
That's Mr. Wallner. Is there a second?
I'll second.
And Mr. Monahan has seconded. Any further discussion? All right, we'll call for a vote. I'll start this time with Mr. Winters.
Aye.
Ms. Spector Morgan.
Aye.
Mr. Monahan.
Aye.
Mr. Wallner.
Aye.
And I also vote aye. The variance is granted, and that concludes case 4120 for this evening.
Thank you.
You're welcome. Our next case is also a recess case, although I don't believe we actually heard anything on this case. This is case 5020 Bubbles Enterprises LLC. Do I hear a motion to take up the case?
So moved.
Ms. Spector Morgan made the motion, and who would like to second?
Second.
Mr. Winters seconded. Mr. Wallner, how do you vote?
Say again?
How do you vote?
Aye. I'm sorry. Aye.
Mr. Monahan,
Aye.
Ms. Spector Morgan,
Aye.
Mr. Winters.
Aye.
The vote is unanimous. We have gone through the arduous task of reopening the case.
Sorry about that. I was just getting the paperwork for the next case.
All right. This is case 5020 Bubbles Enterprises LLC. The applicant wishes to develop an existing structure for use as a 3-unit multifamily dwelling and requests the following. A variance to the table of principal uses to permit the conversion of an existing residential structure to accommodate 3 residential dwelling units on a lot with no frontage, when each conversion requires lot frontage of 80 feet on an accepted city street. A variance to the requirements concerning non-conforming lots, condition for development of a non-conforming lot. Item A, to permit development of a non-conforming lot in legal existence at the effective date of the current ordinance and which does not have frontage on an accepted city street when a minimum of 22 feet of frontage is required. All of this would be for a property located at 85 Pleasant Street in an RN residential neighborhood district. Is there anyone here from Bubbles Enterprises to speak on their behalf?
Yes. My name is Barry Hogue. Can you hear me?
Yes. Mr. Hogue,
Okay.
would you swear to tell the whole truth and nothing but the truth?
Of course, yes.
And would you identify yourself for the record as you testify?
Yes, my name is Barry Hogue. I'm an architect with the H.L. Turner Group in Concord, representing Bubbles Enterprises regarding this variance.
And what would you like us to know?
Basically, I'm reiterating what you just said, sir, that it's it was a 2-family home that was built back in the early 1900s. It's gone through various occupancies over the years. It was acquired by the state hospital, somewhere in the mid-1930s or 40s. And it was acquired recently from the state. And the current owner wants to convert it into a 3-unit residential building. It has no frontage. It has has access through Bavery Lane from Pleasant Street. And I don't know what more there is to to speak of it. The access is through Bayberry Lane to the parking area to the east. There is space enough for 6 units for the 6 vehicle parking. That's pretty much the extent of it.
There's some discussion about an easement to access the site that one of your neighbors has offered. Can you point out where that easement is?
Yes, there's a survey, a boundary survey, and I think Mr. Walker would have it. It goes from Pleasant Street to the building. It shares the driveway. It's right where it says map 37, block 616. There's a right of way to map 37. It's at the top of the sheet. It shares the driveway with the building in front of the subject property. And this right of way was deeded back in like 1914 when the property was originally subdivided. And that's also indicated on that map that you're looking at on the far right. It makes reference to the deeded right of way.
Very good, thank you.
How,
I'm sorry.
I'm sorry. How is the property used now? Is it vacant?
Yeah, well, yes, it's vacant. The last time it was used by, I think, Department of Health and Human Services. They had it as like a halfway house for people that were just ready. They were coming out of some other facility and they were getting ready to be put back into the population. That was the last time it was used. It's been abandoned the state abandoned it for a number of years. And then they finally determined they're not going to do anything with it. So they thought, let's unload it and get rid of it. And that's when these people who currently own it stepped up and purchased it.
So it's going to need significant construction to convert it to any kind of use at this point.
Well, it was originally constructed as a 2-family home. Okay. It has some issues only because of it hasn't been taken care of properly. I think they have been working on making repairs to it so that it doesn't continue to deteriorate. But
May I interject something?
Yes.
Okay, I just wanted to identify myself. My name is Zeus Simeone. I am the property manager there at Bubbles Enterprises.
May I swear you in, Mr. Simeone?
Yes.
You swear to tell the truth and nothing but the truth.
Yes.
Thank you. Please proceed.
Since Barry was speaking of the history of the house and how it is set up, and to answer Mr. Winter's question to how much effort it will take to rehabilitate the house. The house is actually a very nice historical building. It's listed by the Historical Society, and there is a historical easement on it as well. So we can't modify anything on the anything externally in an attempt to keep the historical significance of the building. But we would like to turn it into something very nice and usable, both for ourselves and for the greater Concord area to begin with. And it was, when we received it, it had essentially already been turned into a 3-family building. There are 3 floors, each one of them with a bathroom and a kitchen and a living room and 2 to 3 bedrooms. So actually turning this into a 3-unit house will take the least amount of effort as to any other change, any other use that this could possibly make. It was not zoned as a 3-family unit because the state has had this since 1942 and they're kind of immune to zoning regulations. So it wasn't really zoned for anything. But we are now trying to make use of it as to what it is at this point clearly designed for. While he is correct, and this used to be, it was originally designed as 2 stories. that was probably changed. I mean, two families, that was probably changed 50 years ago to break it up into 3 units.
Thank you. Are there questions from the board? Anyone? Is there anyone who would like to be heard in favor of this appeal?
I'd like to be heard against it.
You'll have your chance.
Good.
Chair Carly, this is Amy Manzelli. I just wanted to let you know that I'm here. I'm legal counsel representing the applicant in this variance request. And we've given you, I gave you a couple letters that document the legal justification for the variance request. But if you wanted me to touch on any of the highlights, I'm happy to do that. But if you also wanted to just rely on the written submissions to speed things along, I'm obviously
Why don't I swear you in and you just touch on the high points, if you would.
Sure.
Do you swear to tell the truth?
Yes, I do.
Why don't you give us a brief tour of the reasons why you think the variance is justified?
Sure. Again, for the record, Amy Manzelli from BCM Environmental and Land Law. Thanks for the opportunity to talk with the board tonight. So the real highlight here is that this is the most logical use for this structure. You've got a residential structure in an area with other residential structures, and the applicant's desire to use it as a residential structure to bring it back on the tax rolls for the city of Concord, and as they said, for their own benefit. So it's a terrific use for this property, given the circumstances around it in the history that you've heard. So turning to the variance criteria, just reading from my letter here, the first and 2 criteria are taken together, and this variance is not contrary to the public interest, and it does observe the spirit of the ordinance, because the key policy for these frontage requirements and the zoning requirements are that they fit within the character of the neighborhood and that there is access for the property. We've touched on already the easement access. I know that you're going to hear some comments from Attorney Stein tonight. So the easement issue is irrelevant to the zoning board's decision tonight. We're not asking the zoning board to make any decision about the scope of easement rights, whether easements rights do exist, whether they don't exist. As you all know, that's a matter for the Superior Court, and the parties here, Attorney Stein and my clients, have an active dispute that they are prosecuting in the proper venue, which is the Superior Court. So the key policy here underlying the frontage requirement is access. They have access. There's no problem there. The next variance criteria is substantial justice. Obviously, this would be a tremendous loss to the applicants here, but to any owner of this property if it were not allowed to be operated without frontage, because there's no set of circumstances moving forward where direct frontage could be had for this property based on where the house is set back from Pleasant Road, based on the historical development of that area. And there's also nothing that the public stands to gain from denying the variance. The public is missing out on a historical gem right now, just getting more and more dilapidated here. And so with this variance, it will allow the restoration of this historic home, which is in keeping with the neighborhood. Touching on property value standard, changing from the currently deteriorating situation of an unoccupied building to a newly refurbished historic gem is very likely to increase property values in the surrounding area, not diminish them. And finally, touching on unnecessary hardship, as we've touched on, this all stems from the state's divestiture of some of its assets around that office complex, and this is one of them. You know, they decided they weren't going to use it. They finally decided they wanted to sell it off. You know, it's really nobody's fault that it happens to be a little bit of an island back there, set back from Pleasant Street. The owners way back when acknowledged that and put the easement in place, so the access is there. So that sets up the hardship situation. It's become landlocked frontage-wise because of that history. So the last thing I wanted to offer is, just in case this board is concerned about the access and the easement issues, in the letter that I submitted today, I said, that the applicant would not object if you wanted to put on a condition of approval. Because what you're hearing tonight is, of course, I'm advocating that there's no problem with the easement rights. Attorney Stein, I anticipate, is going to tell you that there's a big problem and that there are no easement rights. So the condition of approval would be, I put it in the letter, so you have this in writing, but it would say, subject to a condition precedent that the city solicitor's office confirm that the Superior Court has already ordered that the applicant has a right of way to access the Huntress house from Pleasant Street via Barberry Lane. So given the conflicting opinions that you're getting from folks, me being one of them, it would make sense, and we wouldn't object if you wanted to put a condition of approval that your council confirm that there is access. We'd welcome questions, but with that, those are the highlights.
I have a question. And my question is this, and I think, Amy, you'll be able to answer it, but if not, hopefully Craig can. And my question is there any use that can be made of this property without a variance?
Oh, I'm already unmuted. I would not say give it a definite yes. You could probably use it as a single family home.
Even without frontage?
Even without frontage, because the frontage interferes with development and issuing building permits to expand and such. But as long as it's a use that's otherwise a single family home is otherwise permitted in the district, that use can be established on a vacant or a non-conforming lot.
But aren't single family homes still required to have parking? So you would still need the frontage requirement, I think, would still apply.
Oh, I think that from a practical standpoint, there'd have to be access, but
yeah.
I'll just read the section here as soon as I can find it. The use of a lot does not.
Are you looking for section C, the minimum lot frontage?
No, I was looking under the section that states that a single family home or nothing shall prevent a single family dwelling from being established on a lot. Go ahead, continue.
If I can just interject here, even if it would be technically possible to have this as a single family dwelling, we would be talking about an 8-bedroom, 3-bathroom, 3-kitchen single family dwelling. If we were to completely renovate and change it so that there is only 1 kitchen, then we are now talking about a 10-bedroom small mansion in the middle of Concord, which would have essentially no resale value whatsoever. Nobody wants a 10-bedroom house in the middle of Concord. I understand, Andrew, that maybe some people do. But...
Okay, thank you. My question's been answered.
Is there anything else, Ms. Manzelli?
Nothing else from me. Thank you all.
Thank you. Craig, Ms. Manzelli mentioned a letter, which it sounds like may have come to you after my packets went out.
It should be in your it should be in your email right now. I sent it just before the meeting.
Let me take a look.
Was that the one from BCM Environment and Land Law? That one?
Yeah.
Yes.
Yeah. Okay. I got that.
Yeah, I've got it now.
And I think Attorney Manzelli summarized it pretty well just now. If I'm not...
if you can't put your hands on it, I have it available for
I've
me.
got it. I'm just taking a look at it to see if I think it needs to be read into the record. It doesn't look like it does.
Chris, it would be the next to last paragraph that she quoted from.
Beg your pardon?
It was the next to the last paragraph.
Yeah. Which Ms. Manzelli already read into the record. So I'll save us all some time by not reading the rest of the letter. The gist of it is as she described. Very good. Thank you very much. Is there anyone who would like to be heard in favor of this appeal? Is there anyone who'd like to be heard in opposition?
I would.
Mr. Stein, do you swear to tell the truth and nothing but?
I do, sir.
Would you identify yourself for the record, please?
My name is Robert A. Stein. I'm the sole and single stockholder of Barbary Lane LLC.
What would you like us to know?
First of all, just a point of clarification. The letter that was referenced by my colleague, I have as dated October 2, 2020. Is that the letter that has been submitted today?
That we got that letter, Bob, but there's also another letter that was submitted to us, was dated today.
November 4.
That has not been supplied to me, other than addressing that it has not been, and I'm still ready to proceed. May it please the board, the applicant comes to you with unclean hands, impure motives, and seeking rights that he just doesn't have. And the history of this property, which has been in litigation now for the better part of 6 or 7 years, is adequately laid out in one of the 3 Judge Kissinger opinions of the Superior Court. The history is as laid out there, and as I can tell you, different from what you heard already. This house was a single-family dwelling when the deeds, the 1912 and 1913 deeds, were created. They were neighbors, they were friendly. This was all part of the litigation in the Superior Court, and the history is found in the court's opinions, which I've appended to my documents. But the long and the short of it is, in order to accommodate Harriet Huntress, the owner of the Huntress house, the owner of the adjacent property gave her a right-of-way across his property, which kept going throughout the various chain of custody till the present. So from 1912, 1913, there's been only the right-of-way for this property across Barbary Lane, which is in front of my property, my building, which allows access to the Harriet Huntress house. Now, it's been a single family until the state took it over in the mid-40s. And again, it has a historic significance because apparently Harriet Huntress was the only woman superintendent of the New Hampshire State Hospital. And therefore, the building has some historic significance, particularly with regard to the exterior. The state in 1988 essentially abandoned the property. It had been used for a variety of things, including nurses' residence within the property. From 1988 to the present, it's been basically abandoned and in disarray. And then Mr. Bubbles LLC took it over in June of 2018. Nothing's been done on it from June 2018 till the present. Now, back to the litigation with the state. The court found unequivocally that the right-of-way that exists to give access to that property was owned by the predecessor in title, Trella Associates, which was Shaheen Capiella Stein and Gordon, my prior law firm, and now its successor, Barbary Lane LLC, again, adequately laid out in Judge Kissinger's opinion. The state was ordered, contrary to what it wanted, to pay us for use of the right-of-way that they had not used in all that time. The question became, what was equal maintenance as set forth in the deed? And the court made findings, and actually granted a ruling. I think there was 13,000, rings a bell, that the state ultimately paid Barbary Lane LLC for plowing, sanding, lights, and other kinds of maintenance issues, which brings us to the present kinda. Dr. Simonidis and his partner established Bubbles to buy the property. And when they bought it pursuant to a deed, which is in your packet, which references the prior litigation and the rights thereof. And the reason this is important, that house had always been serviced through the State Office Park. When Bubbles took it over, the deed references the prior litigation, as well as the fact that Bubbles, is waiving all claims against the state to allow, yeah, that'd be true. I don't know that I can. There's the property at issue. There's Barbary Lane. This is my office building, which is Stein Law PLLC. The prior access to the building was through the back, through that driveway, and there was another, I do believe. As we set forth in our papers at section 7, the place is filled with asbestos, caving in, sewer and septic in the cellar, pumped out regularly in the spring, and we've watched it deteriorate to the point that before it was sold to Bubbles, this building, Huntress, a building here at the corner of Barbary Lane and Pleasant Street, the Gateway House, and the Kutras House here on the corner of Pleasant Street and Barbary Lane, this, were all to be destroyed because they were deemed to be worthless. Ultimately, the state sold the Kutras House. It was renovated, and it stands at the corner of Barbary Lane and Pleasant Street opposite Merrimack Street. The Gateway House was destroyed and hauled away. This house was used for practice from the firefighters who would hose it down and hide fake bodies there and practice there. It is in terrible condition and hasn't been touched since this purchase. What triggered the second and third round of litigation is when they refused to comply with their own deed and pay me any money for the use of the right-of-way, me being Barbary Lane. So I sued them in a small claims action, whereupon they removed that action to the Superior Court, argued 4 different kinds of arguments why they were not responsible for payment and that the deed didn't mean what it said. And as of this week, actually, per Judge Kissinger's October 27, 2020 opinion, all of their claims were denied. Every theory they had as to why they were not obligated to pay the $800 for the right-of-way was denied. It is my position that they come into this board, therefore, with unclean hands and are trying to do an end run around the Superior Court action. In other words, they want to be able to use the right-of-way instead of just with 2 cars or 3 from a single family, with 6 or 7 plus service vehicles without ever compensating me for the taking of the property that I own, I being Barbary Lane LLC. So that's the unclean hands. Impure motives is the last point that's really bothersome. They're trying to use this board to get an order to be inconsistent with Judge Kissinger's 3 orders, which are all attached to your documents. And Judge Kissinger is abundantly clear that this is a single family right-of-way. It's all it is, it's all they own. And to ask for more than what they paid for from the state or what they should be paying for me would be a taking without compensation. I will say that only recently, come this summer, there has been some renovation efforts to the building. It's been painted. God bless them, they're painting it in maize and blue, my school colors. I'm sure that was not intended, but I appreciate it very much. I don't know what the inside's like anymore, but when the last time I was in, it's loaded with firefighter marks and asbestos as set out in our submissions by our experts who looked at it. It is loaded with asbestos in the paint. It has asbestos on the roofs. And when it's remediated, when it's actually changed, we'll be creating a hazard to anybody who's at my building who happens to be around. It's our position, therefore, that Bubbles waived any claim to expand the use of his right-of-way when they bought it, when they agreed with the state not to use what had historically been access to the building and adequately served it, and that they waived any claims because they knew what they were buying and knew what they were getting into when they did buy it. I am somewhat concerned that the application originally filed by the applicant had a map attached to it or a plot plan attached to it, which I've never seen before. As to whether it's accurate or not, I don't think so. It references septic. I don't have an answer where the sewer and septic currently rests and how they're planning to service this non-conforming use. And I don't have an answer to that, except to say that the evidence that they submitted is inconsistent with what the state submitted in its original lawsuit. So in short, in conclusion, we're asking the following: that you deny the application for the variance. You deny it because it would be interpreting the deed and grants within that deed adverse to the abutter, to me, without compensation, and indeed, as of this point, absolutely adverse to the Superior Court's orders. And they have still come into this hearing never having paid for the obligation to maintain half equal the right-of-way as per the 1912 deed. Instead, they want to go around it and do what they want to do. It is still capable of being a single-family home if that's what they want to do. But as I understand it, it was always the intent to turn this into multiple family homes. That's what Zeus said to me when we met only once, but he's waited a real long time to ask for a variance, which if he had asked this board for a variance before he purchased it, he would not have put himself behind the 8 ball that he now finds himself having waived against the state, having waived the ability of access as had been done since 1912 and 1913. He's made his own problem, and therefore I suggest for all those reasons the application is untimely, and they are here trying to undo the Superior Court's 3 orders. Thank you very much.
Yeah, are there any questions from the board?
Yeah, I have a question, Mr. Stein. So and I looked over the orders, but it was too much to try to digest all of them. So I appreciate your summaries. If it's true that the right-of-way only allows access to a single family, then even if we granted their variance, they would still have you would still have an action against them if they tried to exercise the right-of-way against the deed, correct? Through the Superior Court. In other words, the variance we grant would essentially be useless to them.
They don't need a variance. They already have it. They already have the right of way. He drives over it regularly. It's part of the deed. What he doesn't do is pay for it. And that can be dealt with in a number of ways. So the answer to your question is yes, he does have the access. To be clear, is at the curb cut on Pleasant Street, opposite Merrimack Street, into Barbary Lane, which I own, across the front of my office building, around the side of the office building, and then through the cut to behind his place. Yeah, he can use it as a single family, and of course, ultimately should pay for it and the upkeep and maintenance as per 3 court orders. But it is of concern to me as a neighbor and concern to you as folks who listen to these kinds of things, that people who appear before you follow Superior Court judgments. Now, I appreciate the 3 judgments are hard to, that's why I highlighted them to help you.
Yeah. But didn't you say, maybe I misheard you, didn't you say that the right of way or easement is only limited to a single family?
Correct.
So, okay.
He doesn't need anything. He already has it. He just has to pay for it.
Any other questions? Anybody else wish to be heard in opposition to this appeal? Any comments from code enforcement?
A couple little comments. My understanding of the history of the house is it was built as a single family home. It was a Harriet Huntress and her brother Henry that lived there. So there were two separate individuals living in the property, but I believe it was designed as a single family home. I've been inside the property. It was back probably 2009, and yeah, the interior surfaces, cosmetics of the building are pretty rough. And by the time I'd been in there, it'd been through a winter, and there'd been heat pipes burst and paint was peeling. But it is a very solid building. It's got good bones, as they say. And yeah, it was used more of as a community rooming halfway house. If I recall correctly, there was a small kitchenette, well, full kitchen on the first floor and small kitchenettes on the second and third floor. So it was kind of an open rooming house type setup and not strictly 3 individual units. But I did happen to look at the deed for the adjacent building there, the 2 to 4 Fuller Street, which is where they describe the sewer going. And there is an easement on that deed going out to Oak Street that does grant a permanent sewer easement to Harry Huntress and his heirs. So whether there's anything under the ground there today, I have no idea, but it's still in the deed.
Craig, if the frontage were sufficient, does the property meet all the other requirements to be converted to a 3-family under zoning?
If I didn't put it in the list of variance requests, then they would be meeting those requirements.
Okay. I thought as much, but I just thought I would make sure.
And again, to clarify on the single family use, the section I was thinking about only states that where a non-conforming lot can be used in conformity with all applicable regulations except minimum lot size. So it doesn't reference the frontage on that exemption.
Thank you very
but
much.
It would still revert, again, without doing an opinion, the property would still have a use, and it most likely would revert back to its last legal use, which would be the single family dwelling, as far as I know.
Okay. Ms. Manzelli, do you or your client wish to offer factual clarification in response to anything you've heard?
Thank you. I appreciate the way that you phrased that. Let me just look at my notes real quick here. I think that Attorney Stein's presentation just underscores that we would have no objection if the board wanted to put on a condition of approval, such as what I suggested. We don't believe that there's a taking. We don't believe that any of the payment issues have anything to do with a request for a frontage variance. But to the extent that the board is concerned, it makes sense for the board to seek counsel. And just to emphasize that this is a very, very well-suited use for this large building in this area. Thank you.
You're welcome. With that, we'll declare the public testimony portion of the hearing closed. There was a letter from Attorney Stein to the board, but inasmuch as he has made an extensive presentation, I will simply leave it in the record rather than reading it out loud. We have a request for a variance for frontage for conversion to 3 families for a house that is on a lot that has no frontage because of its original configuration back in the early 20th century. We heard testimony that without some forgiveness on the frontage, they could not convert this to a three-family home, which they otherwise could do. Discussion. What do you think, Mr. Winters?
Well, when Attorney Stein raises, I've never heard that particular objection, and it's interesting to unclean hands. I don't, but I think we're not prejudicing any rights he has in front of the Superior Court. If what he says is accurate, it sounds like that litigation could go on, and there's going to be more of it, unfortunately. But it is going to be an additional burden, obviously, if they put a three-family in there, because there'll be more cars coming and going, and he may have further arguments to make that they can't use it for that purpose, or they would owe him more money. But if we grant this variance, that we're not, we wouldn't, and we certainly don't have the authority to undermine the Superior Court's order. I don't think so. I'm moving past that. So the question is, I think we can consider the variance on its merits without prejudicing Mr. Stein's appeals. I guess I'll leave it at that for now.
Okay, thank you. Laura?
I completely agree. There's clearly a private dispute here over whether the easement exists, and to the extent it does, what it can be used for. That has nothing to do with this board. We don't have any authority to make that decision. We don't have any authority to overrule Judge Kissinger, and I think we all know that. The other issues that Attorney Stein raised regarding payment or asbestos or sewer, also not our issues. If we were to grant this variance, it would be limited only to the question of whether it can be converted to a 3-bedroom without adequate frontage. And it seems to me that this is an appropriate situation where you would grant a variance. The property is unique in that it was created in the early 20th century without any frontage. There is a right-of-way. Attorney Manzelli accurately discussed the purpose and intent of a frontage requirement to make sure there is safe and sane access. Clearly, there is that here, and in the event of an emergency, should the fire department need additional access, I have no doubt they could get to it through the state property. There is a loss to the applicant if we do not grant this variance that is not, in my opinion, outweighed by a benefit to the public, and I do not see where there would be a diminution in value. So I would be in favor of granting both of the variances.
Yeah.
Yeah, I agree with both what Laura and Andrew had to say. It was a long record created tonight that really doesn't have a lot to do with the two items in front of us. I did have a question for Craig, though, with regard to the other structure on, is it Burberry Lane? I think that's the Stein Law Firm. They lack frontage as well. Is there a variance that they get at some point, or is that just grandfathered?
Actually, they do have frontage through Barberry Lane. Barberry Lane is a private right-of-way that actually belongs to the Stein Law Firm office, if
Okay.
I believe that's the situation there. Yeah, and as long as they have 22 feet of frontage, which they may have been actually just a little short, they would be deprived the ability to develop the property further. But they are able to continue and maintain the existing use and use of the property.
Okay, good. Thank you.
Okay.
I agree with what my three colleagues have said already.
I agree as well. Would anyone care to make a motion?
I move that we approve both of the requested variances. I will suggest that we put a condition of approval that legal access be confirmed by the Superior Court, though I don't think that condition of approval is necessary. I think that's implied, but I will put it on there in an effort just to clarify that we're not granting any rights that anyone doesn't already have.
Is there a second?
I'll second.
It's been moved and seconded. Ms. Spector-Morgan made the motion. Mr. Monahan seconded the motion. Any further discussion? All right, we'll go to a vote. Mr. Wallner?
Aye.
Mr. Monahan?
Aye.
Ms. Spector-Morgan?
Aye.
Mr. Winters?
Aye.
The vote is unanimous, as I also vote aye. Both variances are granted.
Thank you very much, all. Good night.
Good night.
Good enough. That brings us to our next case this evening, case 5120, Advantage Signs for 58 North State Street property, LLC, and Nicholson Law. The applicant wishes to install a freestanding tenant sign and requests a variance to Article 2869C2 to allow setback from the front property line of no less than 1 foot, where a minimum setback of 5 feet is required from any property line, for property located at 58 North State Street in a CVP, Civic Performance District. Is there anyone here for Advantage Signs who wishes to speak tonight?
Yes, my name is Josh Messenger. I'm representing Nicholson Law, and as stated, I work for Advantage Signs.
Do you swear to tell the whole truth?
Yes.
Would you fill us in on why you believe a variance is appropriate here?
The customer had an existing sign that they removed, and they're asking to put the new sign in the same exact location as the existing sign. The reason for the variance is because if we were to move the sign to the 5 feet setback, the sign would be on the front porch. It would literally go into the porch. It would not work for this property. So that's the reason for the variance.
If you're replacing an existing sign, why do you need a variance?
Because of the 5 foot setback, I believe, is what the city had told me.
If the structure is fully removed, it can only be replaced in compliance with the current ordinance, and the current ordinance requires the 5 foot setback. The McCandless sign was placed on existing pillars when that was installed, so that did not require an additional setback or a variance.
Thanks, Craig.
So I will just add to that what the customer is asking for is to replace the post with granite posts and a new sign structure.
Is it essentially the same size?
Yes.
Any other questions for Mr. Messenger? Very good. Thank you, Mr. Messenger.
You're welcome.
Is there anyone who wishes to be heard in favor of this appeal?
Yes, this is Neil Nicholson.
Do you swear to tell the truth and nothing but, Mr. Nicholson?
I do, thank you.
What would you like us to know?
Evening, board. Thank you for your time. Just to add on to the comments that Mr. Messenger provided, 3 quick points. I won't take long. Number one is just the history of the particular sign and building. My partner and I, former partner and I, Roy McCandless, and I bought the building in April 2017. We did put a new sign up in the same location as the sign that was there when we purchased the building. Obviously changing out the name of the prior owner. It was a realty business with our law firm's name. And then in April of this year, Mr. McCandless and I went in separate directions for business pursuits. Roy actually moved up the street into Fred Potter's building at 125 North State Street. And I stayed in the building where I'm at now, 58 North State Street. A few months later, went through the process of splitting out the business of the building from Roy. And now, to my wife's chagrin, I think she is a equal member with me at 58 North State Street. The sign during April after the split had to come down. I suppose I could have put a sheet over the name or a piece of plywood or spray painted it or something, but we had to remove the sign during the process of the split and timing to put up a new sign. The new sign is going to go in the same exact location as the one that Mr. Walker had shown on share screen. I will say, so that's the history behind the sign, the timing and such. why there's been no sign there for about two or 3 months now. The second item is just the style of the sign. So the new style, it's Advantage Signs, the same one again that designed Mr. Potter's sign at 125 or 135 North State Street. So you'll have granite pillars with one main sign at the top and 2 smaller signs underneath. And the last thing I would say is that the sign it fits with the neighborhood and the extensive renovations that have been made for this particular building in the past 2.5 years. So for all those reasons, I would ask for the variance, and I thank you very much for your time.
Questions from the board? Is there anyone else who'd like to be heard in favor of this appeal? Is there anyone who'd like to be heard in opposition to it? Any comments from code enforcement?
No, I don't have anything to add at this point.
With that, we'll declare the public testimony portion of the hearing closed. We have a request for a sign to be in the setback where a previous sign was. We heard testimony that there is no other place that the sign could go without putting it actually on the front porch of the building. Mr. Wallner, what do you think?
I think there's a hardship right there. You just stated in your last sentence that there's no other place to put it due to the uniqueness of the property and not able to use a 5-foot setback.
Yeah.
I agree with Nick. I think the hardship is the building interferes with the setback.
Laura?
Well, I agree with the hardship, and I think the other variance criteria are met, particularly where it's pretty much an exact replacement of what was already there.
And Andrew?
I agree with all the other comments.
I do as well. Would anyone care to make a motion?
Move approval.
Is there a second? That was Mr. Wallner making the motion.
It was.
I second.
Ms. Spector Morgan is seconding the motion. We'll begin the voting. Mr. Winters?
Aye.
Ms. Spector Morgan?
Aye.
Mr. Monahan?
Aye.
Mr. Wallner?
Aye.
And I also vote aye. The vote is unanimous. The variance is granted.
Thank you very much.
You're welcome.
Thank you. Have a great night.
Good night.
Night.
All right. The next case this evening is case 5220. Timothy Storer. The applicant requests a variance to Article 2841H, the Table of Dimensional Regulations, to allow the construction of a porch on the southwesterly front of the existing house and to legitimize a porch constructed on the northwest side of the house adjacent to Oak Hill Road to allow the closest point of the new construction, porch size and location shown on submitted plans, to be 7 feet from the Oak Hill Road front property line and allow a front setback of 6 feet from the Appleton Street front property line, where a front setback of 25 feet is required for property located at 1 Appleton Street in an RM residential medium density district. Mr. Storer, are you among us this evening?
I am. How you doing?
I'm fine. Do you swear to tell the truth and nothing but?
I do.
For the record, this is Timothy Storer testifying. What would you like us to know?
Well, I'm asking for the variance because the house sits in a rather precarious position right at the fork in a road. There's a lot of high traffic and there's been accidents in the past. And prior to the porches being there, it was just very exposed coming out either the front door or the side door. There wasn't very much between the door and the road, and it really looked out of place next to the other houses in the neighborhood. So I'm asking for the variance just due to the nature of where the house sits, and that I feel more comfortable there being something between the fork and the house, you know, that being the deck. And in the past, we had trees there, but we agreed to let Unitil cut them down because they were interfering with the line. And aesthetically, it looks much better. It looked very looked awkward before with no porch, just a set of steps coming outside the door. So that's
I see we have a deck there already, and it looks like one of your requests is to bless that deck. Can you tell me what happened?
Yeah, I built that deck prior to asking for. I didn't know about the variance, but I didn't get a permit either. So that's on me. I wasn't didn't really understand all the permitting rules at the time, but so yeah, if you can just imagine there not being anything there and just a doorway on the side of that house, and that in the vicinity to Oak Hill Road there, which gets a lot of high speed traffic. So really, I mean, that's my biggest thing is just having those two, you know, having something between the house and the road there. All that bamboo is gone now. One, because it was a huge eyesore, and two, because people that were turning right off of Appleton Street onto Oak Hill Road heading north, they couldn't see anything. You'd have to really creep out to be able to see any traffic coming down Oak Hill Road. So I got rid of all that bamboo, and it was a process to get rid of all that. But and you know, I know anyone who lives near me will agree that just aesthetically that the house in the property looks much better. You know, since I purchased the place and started working on it, and making the modifications I have.
Other questions from the board? Thank you very much, Mr. Stover.
Thank you.
Is there anyone who'd like to be heard in favor of this appeal?
Yes, I would.
We had a little transmission problem there.
Yeah, just better.
Yeah, just make sure any other speakers are turned down. Yeah.
I'm trying to.
Okay, no, you sound good. You sound fine now.
All right. Who do we have the pleasure of chatting with this evening?
So there's two of us in the room. It's Scott and Crystal Haskell at 3 Oak Hill Road. That lives directly across the street from the property that you're talking about.
Could you, the FI is terrific. Could you give me your last name again, please?
Haskell, it's H-A-S-K-E-L.
Haskell?
Yeah.
What would you like us to know? First, I guess I should swear you in. You swear to tell the whole truth. You still there?
No, speak up. We can't really hear you.
Is this better?
Not much.
Over here.
Hang on 1 second. We're just trying to figure
Oh, we can hear you now.
All right, perfect. So we've been here for about 5 years, and I can say that I do agree with Mrs. Storr that since we've been here, little by little, he's definitely improved his property, and I can say that from the bamboo that he was talking about, we definitely had to deal with that, and that being gone has been greatly appreciated. But for the porch, I would like to just say that, you know, being his neighbor and looking directly at his house, all the little improvements that he's been able to make when he's home. I know he gets deployed a lot with the military, so thank you, Tim, for your service. But yeah, I don't know. I think that porch, I'm going to hit on a safety concern, is that my wife, she's made several calls to the Concord police because his property is right on that corner of Oak Hill and Appleton. And if you ever hung out here for an hour, you would hear, whether it's motorcycles or cars, as soon as they're going towards Loudon from Concord towards his house and towards that fork in the road, as soon as they hit that corner, they're flying. So at least several times throughout the winters, I'm always over there helping somebody out of his yard. And it is a real safety concern. I know Tim has several kids, and honestly, I think, you know, all seriousness, that the porch someday is going to prevent a car from crashing directly into his house. So I think, honestly, it's a great buffer. You know, obviously, for permits wise, Tim might have not went around it the right way, but I definitely feel that for safety issues, this could actually really save somebody's life someday. But just looking at his property and looking how it's tucked into that very corner of the house, I know some of the photos you guys don't get to see. A lot of those trees he's cleaned up and those are gone. So there's really nothing preventing somebody, when they come around that corner, being directly in the yard. I know I've heard past stories from our neighbor, Guy Newberry, which has been there for forever, of, you know, literally taking people out of their cars because they smashed trees in his yard in the middle of the night. So I think for us, the biggest thing is obviously for Tim and his family, the porch definitely, for, you know, eyesore and value wise, I think it definitely makes his house come together a little bit better, because as you can see, the property, it's kind of all pieced together. And I think that he's kind of in a hardship the way that his property is tucked into the corner of that fork in the road. So I'm not sure of all of the justifications for measurements, but I think that porch definitely makes the house come together better. But at the end of the day, I think the biggest issue is safety. And I really do think at some point we're gonna either be talking about somebody crashing into his porch or somebody crashing into his house. And I would just hope to God that, crashing into the porch would be a lot better than crashing into his house and potentially harming somebody. But,
Okay, thank you very much. Thank you very much, Mr. Haskell. Are there any questions for Mr. Haskell? Is there anyone else who would like to be heard in favor of this appeal?
Yes, sir.
Who do we have?
This is Jeff Foote. I live at 92 Shawmut Street.
What would you like us to know, Mr. Foote? Do I assume you'll swear to tell the truth and nothing but?
Yes, sir. I do.
What would you like us to know?
I'll be very brief. I just want to ensure that Mr. Walker received the 2 letters that were sent from us at 92 Shawmut Street, who fully and unconditionally approve what Tim and Ashley are doing at their house. Did you receive those letters, Mr. Walker?
Yes, I did.
Great. I just want to expand upon what Mr. Haskell said. I've lived adjacent to the fork for 30 years, and before that at 6 Appleton Street, who also sent the letter in. So we've been there as a family for about 48 years. Just want to emphasize what Tim's doing. What he's really trying to do is to improve the safety for his family. The existing condition, the house, I don't believe meets the setbacks the house in the house that's been there for 100 years doesn't meet today's setback. So the house is non-conforming as well. And as Mr. Storr testified, he did remove an invasive species, Japanese knotweed, which was very unsightly, to say the least. So we appreciate the efforts that he's made on the property to enhance the property, and we fully support his efforts and hope you see what he's trying to do is an improvement for the neighborhood as well. Thank you.
Chris, your mic is off.
Any questions from the board? Is there anyone else who would like to be heard in favor of the appeal? Is there anyone who'd like to be heard in opposition to it? Craig, any comments?
No, just that I think you got the 2 letters that I forwarded on to you.
I do. And I also have a third, which was emailed. There's a letter from the Foote Family Revocable Trust, Cindy and Jeffrey Foote, which indicates their support for the variance. There is a letter from James and Mary Foote of 6 Appleton Street, who have been property owners here for 48 years and are in support of the variance. And we have an email, which is from Mike and Jessamine Rockwell, who live at 7 Oak Street, and they are abutters to the property and would like to state their public support for the variance. They believe it would improve the aesthetic character of the neighborhood and enhance safety.
I have a question for Craig.
Yes?
Craig, is the house as it exists in the front setbacks? I imagine it must be, but can you confirm?
Yes, I'm fairly certain on the east side that it is in the setbacks, and I haven't technically measured the other side, but it's very close.
Thank you.
Very good. With that, we'll declare the public testimony portion of the hearing closed.
Excuse me, one more point. Excuse me.
Yes.
We're talking as these porches are new. Like, as I said before, we've been there for 48 years, and there were porches and stoops and whatnot on each location before Tim lived at that house. So this is not something new. Has he expanded upon it when he's home from service? Yes, he has. He admitted that, he was a little lax on some of the permitting processes, but there were structures there back in the day.
Okay, thank you very much, Mr. Foote.
Thank you.
We'll declare the public testimony portion of the hearing closed, and we'll invite the board's discussion. We heard testimony that the placement of the house at the junction of the 2 streets creates a unique situation, which can be ameliorated by the porch, both aesthetically and in terms of safety. What do you think, Nick?
Well, if the way the plot is situated in the triangular shape, if that isn't a classic argument for a hardship in terms of uniqueness, I don't know what is.
Andrew?
Yeah, it's incredibly unique, and I can't ever recall hearing a hardship that cars may strike the house. I mean, this is crazy. Hopefully, engineering or the city is looking into the, maybe doing a roundabout or stop signs or something. But it's unfortunately it sounds legitimate. So this is an extreme hardship, and I mean, if the porches are what they need to protect themselves, I'm a little concerned.
Laura?
I'm not buying the safety as an unnecessary hardship argument, but certainly the property is uniquely shaped, and the house's location on the property really leaves no choice here. A porch is a reasonable use, and in order to have a porch here, you need a variance. So I think they meet the unnecessary hardship criteria, and given where the house already is, I don't think this is going to impede the purpose and intent of the ordinance or the spirit of the ordinance. It's not going to decrease surrounding property values. And I don't think there's a huge benefit to the city for denying it where there is potentially a detriment to the property owner. So I think that the variance should be granted.
Well, I thought the safety issue was at least unique, but I agree with Laura. I think there are other reasons for approving the request.
I agree, especially with Laura and Jim. I think the lot is unique and that the porch is a reasonable use. Would anyone care to make a motion?
I move to approve.
Mr. Winters has made a motion. Would anyone care to second?
I'll second it.
Ms. Inspector Morgan has seconded the motion. We'll start the voting with Mr. Wallner.
Aye.
Mr. Winters.
Aye.
Ms. Inspector Morgan.
Aye.
Mr. Monahan.
Aye.
And I vote aye as well. The variance, is it one variance or two? It was two, I believe.
Oh,
Was it?
was it two?
No, it's just one. I'm sorry. Yep, just one.
Okay.
The variance is granted. There's two pieces of the porch, but one variance.
Chairman, can I ask for just like a 3-minute break?
Of course.
Thank you.
Take advantage of that as well.
Yep, me too.
Thank you, everyone.
It's my Halloween costume. I tried keeping up appearances for a couple of meetings, but then I just ran out of steam.
Yeah, I don't blame you.
We'll chart it to COVID fatigue.
Did I just look so comfortable in my flannel?
Yeah,
feeling
I
chilly?
saw you and I thought, this man has it right. So I'm going to do it instead. Okay, I think we're back in business. Craig, are you here?
I don't see Jim yet. Jim, are you there?
Oh, no, we don't see Jim.
There he is.
Hey, Jim. Craig, are you here?
Yes, I am.
Oh, okay, then I guess we can move on to the next case. That is case 5320, John Radley. The applicant wishes to establish a two-family duplex dwelling and requests a variance to Article 28.5-2 duplex or two-family dwellings to permit the establishment of a two-family duplex on a lot with 100 feet of frontage where 120 feet of frontage is required for property located at 15 Cross Street in an RN residential neighborhood district. Mr. Radley, I believe you are among us.
Can you hear me?
I can. Do you swear to tell the truth and nothing but?
Yes.
The record will show that this is John Radley speaking. What would you like us to know, Mr. Radley?
I think actually there's two of us. This is Jeffrey Christensen from Cleveland Waters and Bass. I represent John Radley. And John Radley is also on the call. Yes, sir.
What would you like us to know, Mr. Christensen?
So this relates to the property at 15 Cross Street. The property is a 24,000 square foot lot that is currently a single family lot or a single family residence that Mr. Radley is renovating and converting to, or hoping to convert to, a duplex. This property is in the RN district. The district allows duplexes as of right. There are, in fact, several duplexes and larger multifamilies in the area. I believe both properties next door are duplexes. There's another one more down the street, 21 Cross Street is a 4-family. Across the street is another duplex and a 7-unit residential condo, other duplexes and multifamilies in the area. This property is in fact larger than all of those other duplexes, or at least the majority of them. I think it might be smaller than the 7-unit condo. Large enough to be suitable for a 2-family. However, because of the quite irregular shape, and you can see it on the screen right now, I believe it is a very irregular shape with about 10 sides, carve-outs. This irregular shape reduces the actual frontage that is on the property more than you would expect for a property of this size. The ordinance that, while it does allow 2-family duplexes in this district, it does impose increased minimum lot size and minimum frontage requirements on those duplexes. The property is large enough, the minimum lot size is 15,000 square feet. This property, as I said, is 24,000 square feet, but it's just shy of the frontage requirement. It needs 120 feet for a duplex. We only have 100 feet here. So that's the variance that we need, is just for that frontage. The application, the written application that was submitted, addresses all 5 of the elements for a variance in detail. I'm happy to answer any questions about them, but just for the sake of brevity, I'm only going to touch on the highlights here. The main highlight being the hardship that is imposed on this property. A 2-family is a reasonable use on this property. They're all throughout the neighborhood. It's a permitted use in this district. The heightened frontage, however, the heightened frontage requirements prevent that reasonable use. The property is more than large enough to support a 2-family. The building is more than large enough to support a 2-family. The only reason it doesn't have that 120 feet is because of the odd shape of the lot itself. That's a good image of the property there. That barn in the back is coming down, I believe. And it's being replaced with that side addition. The use, as I mentioned, is consistent with the area. It will not alter the essential character of the neighborhood. You can see actually on this property, the building on both sides are both duplexes. That one, just one down to the right, that's the, I believe, the 4-family. Across the street, it's a duplex, and then there's the condominium there. In the top left corner, that it looks like a red brick building. I believe that one's also either a duplex or a multifamily. Next to it's another there's duplexes all over this place, or multifamilies as well. There's no reason to prevent a duplex on this property and in this area. Frontage and other area requirements, like frontage requirements, are generally about preventing overdevelopment of lots, controlling density, preventing overcrowding. You can see the area is not overcrowded. The building is a building that exists. It complies with the applicable ordinances as it is. Nothing is going to change about the building from its current use as a single family to a two-family. So there's not going to be any impact on crowding, density, no adverse impact at all. The building is the building. In other words, the variance will only affect the interior of the building. It won't have any effect on the neighbors or anybody who doesn't live there. There's no connection, no purpose in preventing this lot from being a two-family merely because the frontage is lacking 20 feet.
Anything else?
Unless the board has any questions, that's all we have.
Questions from the board for Mr. Christensen or Mr. Radley? Thank you very much. Is there anyone who would like to be heard in favor of this appeal?
Yes, hi, this is Nawaz.
Could I get your name, please?
Yes, hi, this is Nawaz Azam.
What would you like us to know, Mr. Azam?
I would like to say that I am the neighbor across the street, and I am in favor of this property. It is a very large house. It has enough parking, and the work on the house is top-notch, looks very nice. So it will definitely add value as a nice duplex.
Any questions for Mr. Azam? Thank you very much. Is there anyone else who would like to be heard in favor of this appeal? Is there anyone who would like to be heard in opposition to it? Any comments from code enforcement?
No, I don't have any comments at this one at this time.
Very good. In that case, we'll declare the public testimony portion of the hearing closed. We have a request for forgiveness, a variance for 20 feet of frontage for an existing building that the appellant would like to convert to a two-family. We heard testimony that the facilities are adequate as they are, more than adequate, and that the peculiar shape of the lot contributes to its frontage being rather small for the amount of area that it has. Discussion. Let's start with Jim.
Yeah, I think you summed it up there, Chris. It's a very uniquely shaped lot. I think exactly the reason why we're given the authority to grant variances.
Laura.
I agree. And I think that Attorney Christensen properly summed up the purpose of the frontage requirement would be to prevent overdevelopment of the neighborhood. Clearly, this neighborhood's not going to be overdeveloped. The lot is large enough to accommodate this. It's just short 20 feet of frontage. So I think the variance criteria are met.
Nick, your mic's off.
Sorry about that. The character of the neighborhood is such that duplexes are pretty common, and there's certainly smaller lots in most cases. So I think that's the applicant would be denied reasonable use of the property if they couldn't do a duplex.
Andrew.
I agree.
I agree as well. Would anyone care to make a motion?
I move that we approve the variance.
That was Ms. Spector Morgan moving approval. Who would like to second?
I'll second.
Mr. Winters has seconded. Any discussion on the motion? All right, we'll begin polling with Mr. Winters.
That was Mr. Monahan, I think, on the second, wasn't it?
Oh, did I misunderstand?
Just for the record, yeah. Okay.
I apologize, Jim.
I know that was your field on the technicality.
Okay, Mr. Winters, let's hear how you vote, please.
Aye.
And Mr. Wallner.
Aye.
And Ms. Spector Morgan.
Aye.
And Mr. Monahan.
Aye.
And I vote aye as well. The variance is granted.
Thank you very much.
You're welcome. That brings us to case 5420, Abbott Farm LLC. The applicant wishes to subdivide a lot from an approved attached dwelling condominium development, resulting in one lot with an area of 14.83 acres, Lot A, and a 0.45 acre lot, Lot B, and requests the following variances. To Article 2845D5, perimeter buffer required to allow a 9.5 foot buffer setback between the building 2, as shown on the plans, and the proposed property line where a 50-foot perimeter buffer is required. And to Article 2845D5, perimeter buffer required to allow 10 feet between building 5 and the proposed property line where a 50-foot perimeter buffer is required. And to Article 2845B5, perimeter buffer required to allow parking to be located on Lot A within 10 feet of the easterly proposed property line when parking is not allowed within the 50-foot perimeter buffer. And to Article 2845E5, perimeter buffer required to allow a driveway accessing a property that is not part of the attached dwelling development when driveways are not permitted within the 50-foot perimeter buffer. All for property located at 4 Cleveland Avenue, aka 382 North State Street, in an RN residential neighborhood district. We have someone here from Abbott Farms or Abbott Farm LLC to fill us in on the details.
Yes, good evening. My name is Attorney Elizabeth Nolan. I am with Nolan Law PLLC out of Nottingham, New Hampshire. I represent Abbott Farm. Additionally, on the line this evening is Mr. Jason Garland, who also represents Abbott Farm.
Do you both swear to tell the truth and nothing but?
Yes, I do.
What would you like us to know?
Well, just again, I would like to start briefly with just some background as to why we're here this evening. Abbott Farm owns the subject property for which we are seeking variances this evening. It is currently the site of the Abbott Village condominiums. So there are some buildings that have already been constructed and some buildings have not yet begun, as reflected on the plans before you. As we have gone through the development of the condominium, one issue that has come up multiple times over a somewhat long period of time is the Abbott House. So I'm sure you're all familiar with the Abbott House. It is a 1760s Federalist style single family home that has been on the subject lot since its original construction. It currently is still standing today. The Abbott Farm has done some maintenance and repairs on the Abbott House within the past year or so, replacing siding, roofing, windows to make it structurally sound. We have worked very closely with the planning department and also have cooperated with other and gotten the advice of other boards, including the Heritage Commission in the city of Concord. So really what our overarching goal is as follows. We would like to develop Abbott Village as a condominium, but we also would like the Abbott House to remain as historically preserved as possible. Now, what we have come up against is it is difficult to have the Abbott House be restored to its former glory, which is very important to many members of the Concord community, with my client who is a developer. So working together with the planning department, we have come to some kind of an idea that we would look to be subdividing, which is of course separate from this consideration. I'm just trying to give a little background. We would like to subdivide the Abbott House from the master lot into its own proposed lot B, as shown on your plan, which would consist of the 0.45 acres. So the reason that we are here this evening is to request the variances for the buffer requirements. When we really put a lot of thought into this, in how can we make a good enough lot so that the Abbott House is a really desirable thing for somebody with historical preservation just in their bones to want to come and take it, to preserve it. We want as much of a market as possible because the goal is my developer client will in fact look to transfer this holding, this proposed lot B with the Abbott House with restrictive covenants over to an individual that would be able, or a society that would be able to really preserve it. It is not considered a historic building, but of course it does have historic value because it's been in existence since the 18th century. So we come before you this evening with our proposed lots. Of course, when we look at it, the existing Abbott House is extremely close to the road and it's a little weirdly shaped in the rest of the lot. So what we have proposed is a good lot that would make this an attractive parcel to convey to another party. But we do require variances because the lot lines that we are requesting are too close to building 5 and building 2 specifically, as shown on the plan. A 50-foot perimeter buffer is required. We will not have that length. Similarly, we look for the variance in order to allow the parking to be located and for a driveway that is to be placed there for access purposes. So long story short, that's why we're before you today. So just to briefly touch on our actual application itself, to first kind of go into the unnecessary hardship prong, since that definitely takes the most kind of consideration when we're looking at this kind of thing. We have a unique property here. It's unique not only because it's improved with a condominium development, which is still under construction, as I mentioned, but also because it has this Abbott House on it, it's a really interesting building in itself, and it's just been around. It's a landmark, in my opinion. So again, the property owner is seeking to subdivide the Abbott House and associated land from the condominium to preserve the Abbott House and transfer it to a third party. So we believe that this is a reasonable use of the property because my developer client would be able to continue to develop, which is permitted in his zone, but at the same time is showing a great amount of care in wanting to keep the Abbott House as preserved as possible. That kind of segments into the next prong, that no fair and substantial relationship exists between the general purposes of the zoning ordinance and the specific restrictions. One of the specific purposes is to preserve the historic resources of Concord. We believe that the Abbott House does fall into this category of a historic resource. Just because it's not a designated historic property does not, in my opinion or in our opinion, mean it's not a valuable historic resource. We would love to see this be a well taken care of structure that can last for generations to come. Concord has such a rich history. The Abbott House is a part of that, and we would like it to be preserved as best as possible. So we believe this is very in keeping with the actual spirit of the ordinance, the specific purposes of the zoning ordinance. Our application goes through all of the different highlights of each of the criteria, but just to synthesize, we believe that it is not contrary to the spirit and intent because it's consistent with uses in the subject property as neighborhood residential zone. It's in keeping with the essential character of the neighborhood. Again, there are condominiums already there. And so we're not looking to construct anything. We're not looking to even move anything that hasn't already been approved by site plan. We're simply looking just to allow a division to be made such that these are 2 separate parcels. Again, really with the similar reasoning, it would not be contrary to the public interest because it does not alter the essential character of the locality nor violate any of the basic zoning objectives. It would result in substantial justice, in our opinion, because the general public would not realize an appreciable gain from the denial of the variance. In fact, I believe the general public would realize an actual gain from the variance being granted, because it allows this historic gem to continue to exist, but not even just in its current state. It could be carried on for generations and be preserved by people who have a passion for it and who have the know-how to do it. As we speak now, it is owned by Abbott Farm LLC, which again is their developers. They're not in the business of historic preservation. We would like this variance so that we can work with other approvals with the planning board to subdivide, to get this over to someone who can really take great care of it. And again, the authorization of the variance will not diminish the value of the surrounding properties, because it's not altering anything that's there. If anything, it may raise the property values, because it will allow that the transferee who receives this property to continue what Jason and Abbott Farm have been doing already, which is to restore it. But they could bring an even better eye to that in terms of making it more accurate to what it may have looked like when it was first built, and to that effect. So just to kind of sum it up, the reason that we're here for these variances to the setbacks, is so that we can create, hopefully, a subdivision of this Abbott house with associated land, so that we can subdivide it, transfer it over to another party who would be able to embrace it more as a historic property, and keep it for as long as possible while the condominium development can be completed and the residents of the condominium can continue to enjoy what they currently have there. We have spoken with the Association of Abbott Village, and they are generally in favor of the subdivision occurring and having the Abbott house be taken over by a party that would have more interest in keeping it as a historic resource.
Any questions from the board? Craig, I have a question. Oh, sorry, Andrew.
That's okay. I just want to make sure I'm following along. You have 4 requests for to reduce the amount of perimeter buffer. Will that be only the larger lot that you're subdividing from that is a perimeter against, or is it
Absolutely.
Okay.
Yes. So this is all currently one lot. So what we're looking, and the master lot is all owned by Abbott Farm. So what we're looking to do is actually split this master lot into 2 separate lots. So it's entirely surrounded by what is the Abbott Village condominium. So it doesn't affect any other, it wouldn't impose on other properties.
So you just don't have enough space to carve out from to allow the 50-foot perimeter, or not even
That's
close?
exactly it. And in addition, to not having the physical space, we're very mindful that we want to have enough space allocated to the Abbott house so that it's really a desirable area for someone to take it over. I mean, what we envision is that there could potentially be monuments or some kind of gardens there, something like that. So we would like it to have the 0.45 acres that we've proposed, because it just makes it into a very appealing thing, as opposed to just doing something ultra narrow, which, as you mentioned, even if we did it right around the Abbott house, I mean, we still wouldn't have room for the perimeter buffers.
Other questions from the board? Thank you very much, Ms. Nolan.
Thank you.
Is there anyone who'd like to be heard in favor of this appeal? Is there anyone who'd like to be heard in opposition to it?
I would like to, if I could be heard.
Yes, of course. Could you identify yourself, please?
course, this is Laura Scott, 35 Callaway Drive, Unit 7.
Sounds like a familiar name.
I know.
What would you like us to know, Ms. Scott?
Thank you. I'm sure I'm not going to be getting many fan letters from my neighbors, but I would like to say that I am in opposition to this request because for a couple of reasons. The Abbott House was always meant to be part of this development. There's a long history of it. There were fights over it, of keeping this house as part of this development. It was well known to every owner, as well as this developer, who was not the original developer, that this was a requirement of this development, was to keep this house as part of the development, but also to retain its historic character. The only reason I've heard from the applicant and in reading the paperwork is to restore it. The restoration and preservation of this house has no relevance to the buffer requirements. The only reason they need the buffer variances is because they want to sell it without reducing the number of condo units that they were approved for. So that is it. They could easily meet the buffer requirements by reducing a unit in each one of those adjoining buildings, and they're choosing not to do it because it would be, they would lose money, which I understand why they don't want to do that. But I don't think there is a relevance to maintaining that house the way that it's supposed to be maintained and then the buffer requirements. I know that there are people interested in purchasing that property if it becomes available, but again, it could be built without the variances, or could be subdivided without the variances. And again, there's no hardship. The only hardship they cited was they want to preserve and protect the house, and therefore they need the buffer relaxation. So I don't think it meets the spirit and intent of a variance. And again, every property owner in that development had access to know that that was a requirement to maintain that house.
Any questions for Ms. Scott? Thank you very much.
Thank you.
Is there anyone else who'd like to be heard in opposition? I do have a letter here, which was from Elizabeth Nolan Orsi. I'm submitting my comments on Abbott's Farm's request for variances to property line buffers. I'm opposed to any reduction in perimeter buffers that would infringe on the Hillcrest Avenue property owners for the purpose of providing additional parking behind existing condominium buildings number 5 and 11, as well as a proposed building number 7. A change in the buffer from 50 feet to 10 feet would eliminate the privacy berm separating Hillcrest Avenue properties from the condominium buildings. This is a major change which impacts both the privacy and property rights of the abutters on Hillcrest Avenue, and a drastic change to the design. I'm also opposed to reducing the property line buffer around Abbott House, since the current intent is to separate that parcel from the condominium development and sell it. Reducing the 50-foot buffer in areas connected to the Abbott House would adversely impact the potential for new owners of the parcel to affect changes to that property. Any comments from code enforcement?
No,
code enforcement.
No, I don't have anything additional to add. Like I say, the area being impacted is just this area over here. There shouldn't be any impact on the area adjacent to the properties on Hillcrest Avenue.
Thank you. Ms. Nolan, would you like to offer factual clarification briefly to anything that you have heard?
I think it's all more or less already been covered in my presentation. I would just say that this does not impact the Hillcrest properties. Again, I would just look to the locus that we're we're looking at here, and again, one thing I would like to mention is that we are not seeking to make money off of this transfer. I don't know how relevant that is to this board's consideration, but I think it may be prudent for me to mention that we are looking to actually transfer this with little to no consideration. Really, our only goal here is to.
You're quite right. The financial details of it are not part of our concern this evening.
Okay, then I will. I think everything has been covered, unless Jason would like to mention any other details.
Very good, thank you. With that, we'll declare the public testimony portion of the hearing closed. We have a request for several perimeter buffer variances, all of which evolve or descend from the fact that the Abbott House itself is a bit of an anomaly on the condominium development property, is not itself a residential condominium, and we heard testimony that they cannot subdivide it away from the rest of the property without this forgiveness. Andrew, what do you think?
Well, at the outset, I think we've come across these before, but I find it a little awkward when the standard is the lot, at least in the first instance, but they're creating the lot. So I know we've had this come up, I think, with the pocket development, and I had the same question. So I'm trying to wrap my head around that. But beyond that, I'm having a hard time seeing the hardship. I do think that, although it does sound like there's good intentions, I think there could be the space there if they wanted it to. It just seems that it's an election not to. So and it's a pretty extreme variance. I think they're going from 50 feet to less than 10. So I'm inclined to deny the variance.
Nick.
Yeah, and I'm also looking at the design of the lot to try to meet the minimum lot size, and I think it's a pretty extreme reduction in setback requests.
Andrew.
Andrew already went.
I agree.
Oh.
I agree 100%.
It's past my bedtime. I start to get a little goofy.
Well, I think we're all a little goofy after last night.
Laura, what can you tell us about your views on this?
I too am struggling with the unnecessary hardship criteria. I just, they're creating the issue by creating the lot, and I understand their purported purpose for doing that, but I don't think there's anything about keeping this house with the development that keeps it from being restored or renovated or protected or whatever they want to do to it. I agree with Ms. Scott that they could meet the requirements if they got rid of unit 2.5 and 8.1, but they don't want to do that. So they sort of want to have their cake and eat it too, and I'm just not sure that that's a good enough reason to grant a variance or several variances.
Yeah.
Yeah, I agree. I mean, they've created the hardship themselves. I did have a question though for Craig, and the case was made by the applicant about the hope to transfer it to a third party who would preserve it and take care of it. But is there any assurance that would happen? It may well be they can't find anyone who's willing to take it, and it continues to fall into disrepair or is demolished at some point.
Well, I haven't been involved with those discussions, so I don't know the details on them. But yeah, once it's sold, unless there are conditions placed by the planning board, but yeah, I don't see the planning board could place conditions on a piece of property that is no longer under somebody else's control. So I don't see that they could tell Abbott Village that they have to do something after the fact. On that. So yeah, I hope that answers your question.
Yeah, and I'm inclined to vote against it simply because of the creating their own hardship. But I would have been more persuaded if the applicant was here with the Historical Society or LCHIP or somebody like that saying, hey, we really want this property. I'm done.
I'm inclined to agree with my colleagues. The building is something of a white elephant. It's been part of this development from the very beginning. The development has come down a bumpy road over the years, but it is now seems to be prospering. The condition that building be preserved was, as Ms. Scott pointed out, always part of the development scheme and the city's prior approvals. So given the fact that they needed all these variances to essentially change course, because that's what they'd like to do, I don't see that being forced on them. I think that's something that they've elected to do, and therefore it doesn't result in a hardship.
Mr. Chairman, I just got a note here that Jason would like to speak, but I don't know, you're into your deliberations.
Well, now, once we've started deliberations, we don't take any more testimony.
Very good.
Thank you. Would anyone care to make a motion?
I'll take a stab at it. I move that we deny the requested variances because there is nothing unique that stems from the property as opposed to the desires of the applicants. And while creating a hardship is not in and of itself, a self-created hardship is not in and of itself enough to deny a variance, in this case, there's no real need to create this new lot. It's an option because the developer does not wish to or is not able to preserve the house in the way it's required to do so. And the necessity for the variances is further necessitated by the developer's choice to not alter the condominium development by removing units 2, 5, and 8, 1.
Is there a second for that, for anyone who can memorize the entire thing? Anyone make a second?
I'll second because Andrew's on mute. So.
That's always a good reason to second. It's been moved and seconded. Is there any further discussion? We have a motion before us to deny all of the variances for the several very good reasons that Ms. Spector-Morgan cited. Any discussion? All right, we'll begin with Mr. Monahan on the vote.
Aye.
Ms. Spector-Morgan.
Aye.
Mr. Wallner.
Aye.
Mr. Winters.
Aye.
And I also vote aye. The vote is unanimous. The variances are denied. And that brings us to our last case on the agenda this evening, which is case 5520. The applicant wishes to use an existing property. It's Katie Kaler, and the applicant wishes to use an existing property and buildings for a single bay automotive repair facility, principal use J4, and requests the following variances to the article of table of principal uses to allow a single bay automotive repair facility where such use is not allowed, to the articles concerning access, circulation, parking, and loading, section 1A, applicability, to maintain the existing non-conforming parking and circulation layout when compliance with the entire section is with the entire section as applicable is required, and Article 28.6.8, signs permitted in residential districts to permit 3 building signs with a combined area not to exceed 30 square feet, where 1 sign is permitted per lot, with a maximum area of 20 square feet. This is for a property located at 49 West Street, aka 14 Spruce Street. I'm not quite sure why that is, but we'll get to that. And an RD residential downtown district. Is Ms. Kaler or someone representing her here?
Yep, I'm here.
Do you swear to tell the truth and nothing but?
I do. And I'm here with Brian George.
What would you like us to know?
Well, so this property was an automotive garage from 1965 up through 2009. it was my father's house, and I was under the impression that it was still a commercial space because it's zoned that way, and the property, it's mentioned on the property tax cards. And I've been paying commercial rates on utilities, water and sewer and such. Also, I wasn't aware that, I just wasn't aware that the permitted use had lapsed. And so that's why we're here today, trying to reestablish the pre-existing use.
Can you tell us why you feel the variances are appropriate?
I feel that it's the, I just feel like it's the intended use of the property, and that was kind of the goal when I purchased the house from my father's estate. And this is what I want to do. I think it'll be a benefit to the neighborhood. I'm an experienced mechanic. And so I think that I guess I was confused. I'm confused on why I needed the variances, but now knowing that, I've supplied documentation of what I've done to improve the property, to bring it up to code, today's standards. Yeah.
Are you living there now, or is it just you?
I do. Yep. Me and my wife live in the house.
Uh-huh.
And so I'm going to continue to live in the house and just operate the business out in the garage.
So this would be a business that you would operate?
Yes. Yep.
Okay. Questions from the board?
Are there other businesses in the area?
There are. There's a daycare directly or diagonal across the street, the top spot. That was always West Street Market. There's the Ward House 2 blocks down on the corner of Badger. There's a hair salon and a few medical offices further down on West Street. And then, close by, there's McKee Square that has restaurants and a Rite Aid. So, I don't think that I will be. I feel like it's a consistent use in the neighborhood.
Can you tell us a little bit about the intensity of the use?
Sure. So I don't know if I think you guys all got a copy of it. So I'm planning on doing pickup and drop off service. Probably scheduling, 3 to 4 appointments a day to minimize traffic. And I'm just trying to start a small business and keep myself busy. I don't want to end up expanding past the space and the resources I have. And it's a single bay. It's, as you can see in the picture, the first picture you showed was prior, that was before I bought the house. So to update, I put a 12-foot door in to accommodate just a single bay versus the 2-bay design of the old 8-foot doors. So that's the 12-foot door. And that is the main space. And so, yeah. I'm sorry, I'm not very good.
No, that was perfect. Thank you.
Welcome.
May I speak?
Who are we hearing from?
I have Brian George with me as well.
Would you swear to tell the truth and nothing but the truth, Mr. George?
I do.
What would you like us to know?
I'd just like you to know that when Katie's dad passed, she did purchase the property from the estate. I believe that if you look at the records, it's always been from 1965 to 1985 it was registered as a business in the very same neighborhood, the very same type of business. Further purchased it in 2004, which I'm assuming he was in 1990. And I'm assuming from what I see here that he received a variance in 2004 to operate a garage out of there, probably a one bay. He carried that on until 2009. He had a second business, which he sold, and he had to sign a no-compete clause, which the property that he lives at fell within the parameters of the no-compete clause. So he was unable to continue the commercial license for the building. Katie was unaware of that. When she purchased that, she was fully expecting that she was going to be able to carry it on. And it wasn't until recently, when she's been working on it to bring her business back, that after a 12-month period of not being registered as commercial, that she would be, that would lapse and she'd be unable to carry on with that, which is why we're here. I feel as she does that, though it did lapse, historically, it's pretty much always been a viable business in that area. What's that?
I was going to say that to bring up I know there was some confusion with the 8A 14 Spruce Street. So the buildings are physically separated, and that was always 14 Spruce Street. I'm not sure at what point it lost its address. I think there was something that happened with a merger of the lot, an involuntary lot merger. So that building does have completely separate services. It's got it has its own water and sewer, electric, and gas service to it. So it is a standalone building on the lot. So if that clarifies the 14 Spruce Street confusion in the two addresses.
Got it.
Can I ask one more question?
Sure.
I see. So if it's a single bay, does that mean it's only going to be one mechanic working at a time?
Yes. Yep. So I'm gonna be the sole mechanic, the tech working there, and then I may end up having someone coming in and helping me in the office and doing appointments and helping with picking up and dropping off. But I'm physically going to be the only one working there in the shop. And also, I've spoken to all of my neighbors, my direct neighbors, and they all are in support. I know a few of them have written in, or I'm not sure if they're still with us. It was a pretty long meeting, but I reached out to everyone to get their thoughts, and I think it seemed like the only confusion was about the signage. And then once I explained, it's 3 signs. One's going to say the office above the office door. I don't know if Fred can bring up that picture again of the face of the building. There's now an entrance door where that window is. So right where that window is, someone hit my building last year, and so I put a door in there. So one sign is going to be that just says office above that door with an hours of operation sign, and then a large sign attached to the face of the building that states the business name. And that's the clarification. So looking at this picture from that large door, that's what I'm considering the main bay of the shop. That's the rest of that is not part of the business. I'm not trying to open up a 5-bay service station. So I don't know if that clarifies that.
Any other questions for Ms. Kaler?
Yeah. I guess I guess the signage question is answered, but what about on-site storage? Will people be leaving cars overnight or for multiple days? That could be...
No, that will be minimal. That's why I'm trying to go with making appointments and offering pickup and drop-off service. And I'm going to be focusing on, routine maintenance. I'm hoping to become a state inspection station. And so repairs that can be done in a minimal amount of time, so that I don't have the space to be housing multiple cars, and that's not what I'm going for. A lot of larger jobs take up that time, and you end up sitting with cars for, you're waiting on parts or engines or transmissions, and I only have one bay, and I need to maximize that for not tying it up for multiple times. And also, I'm going to restrict towing to operational hours. And I'm not going to allow any unattended vehicle drop-offs because of the liability and again, for that reason of not ending up with cars there that I don't know what they need. So that's kind of
Any other questions? Thank you very much, Ms. Kaler. Is there anyone who would like to be heard in favor of this appeal?
I would.
May we have your name, please?
Yes, sir. Kenneth Cox. I live at 17 Spruce Street, directly across from Katie's place.
You swear to tell the truth?
I do, sir.
What would you like us to know?
Just short and sweet. This business has been there since we moved in 20 years ago. And Katie's dad used to, he was a mechanic, great guy, good neighbor, always willing to reach out and help everybody. And Katie's kind of just picking up the ball after the loss of her father, and she's pretty much doing the same thing. It's a daytime business. I'm really the person that's probably the most affected by it because I'm directly in front of her. If you look, I don't have access to your aerial view there, but if you look
Greg,
at
can you pull up the map?
17 Spruce Street, literally sits directly across from it. And we've never had any problems with traffic, with customers, with anything. It's always been, it's a community service center for, one or two cars at any given time, and we've never really had any problems with it. And not only that, she's adding to the community because there's a lot of customers that Doug used to have, her father, that are all in the area, and that she'll probably get back. And I don't think it's really going to impact anything other than just, adding a little bit of extra service to the area. So.
Any questions for Mr. Cox? Thank you.
Thank you, sir.
Is there anyone else who wishes to be heard in favor of this appeal? Is there anyone who wishes to be heard in opposition to it? Any comments from code enforcement?
Nothing in particular, just to verify that this is a situation where you had a pre-existing non-conforming use. I don't have details on exactly when it was established, but it was a non-conforming use that pretty much sat fallow for a period of time, and sitting there being unused, you do lose the right after a 12-month period or so. So they're just trying to reinstate, as they stated, the use that had been there previously.
Thank you very much. With that, we'll close the public testimony portion of the hearing.
Hey, Chris?
Pardon? Yes.
I think there was a letter submitted by Heather Shank.
Oh, I do not have that, or do I have it and not realize it?
Well, I got two of them, so maybe I got your copy.
Well, gee whiz, in that case, why don't you read it, please?
Heather Shank from 19 Spruce Street is writing in support of the variance request. remarking that it's historically been conducted on this property by her father. It already has the appearance and character of a small, well-maintained commercial garage. I and other neighbors I have spoken with feel that the allowance of the use would not dramatically change the appearance and character of the neighborhood. The signage she proposes would face West Street, not any of the residents on Spruce Street, though it would be visible as one first turns down the street. I have no opposition to the signs and feel that it is a reasonable allocation of square footage to accomplish its function while still being visible to potential customers on West Street. I also feel that the signage normalizes the already non-residential appearance of the garage. Heather Shank, 19 Spruce Street.
Thank you, Nick.
You're welcome.
With that, we'll declare the public testimony portion of the hearing closed. We have a request for, I believe it is 3 variances, all of which are related to a request to reuse what was formerly an auto repair, or a facility as an auto repair business. And we heard testimony that it has functioned well in that location for many years, but that use lapsed for a year, and therefore the non-conforming use also lapsed. Andrew, what do you think?
Well, I'm persuaded as to the use. I think although it lapsed and therefore she must require the variance, the fact that it was used for so long in a very similar way to me is persuasive, that it doesn't impose on the neighborhood or it's not out of character. I didn't hear much talk about the variance to the access and circulation and loading, but I think the fact that it's limited to one car and one mechanic at a time, and we did see it's a pretty large lot. It clearly is going to support that use, and it didn't look like there'd be any issues with customers getting in and out. I'm not sure about the sign. To be honest, I didn't quite catch the rationale, so I'm going to defer my opinion on that one, and maybe someone else caught exactly why she needs 3 signs.
I agree with all of that. In terms of, I know there wasn't much discussion about variance number 2, but if there was a plot plan issued to us and it shows 1, 2, 3, 4, 5, it looks like 6 parking spots. So I think that would certainly address the issue. Since this is a one-person operation, I think that's more than they need on a daily basis.
Laura.
Well, I'm going to resume my usual position of naysayer, and while I really appreciate what she's trying to do and the history of the property, the purpose of zoning is to separate uses into appropriate districts, and this is a residential district. And this prior use must have either been non-conforming or zoning must have changed since it stopped. The purpose of zoning is to reduce non-conformities to conformity as quickly as possible. While the property is particularly well suited for this use because it has a large garage on it, that's not the standard. The standard is that there's something about the property that makes it different than other properties in the district that would justify a different zoning treatment, and I don't see that. So I would deny the use variance, which means I really don't even get to the other 2 variances.
Ms. Kaler, we can't accept any more testimony once we've closed the public hearing.
Okay, sorry. All
right. Mr. Monahan, Jim, what are your thoughts?
I am inclined to support it. I think there's some extenuating circumstances surrounding the lapse, and it is, as we've heard from everybody who's testified, for quite a while, this use has been part of this property, and there is no opposition from the neighbors.
I am also in favor of the appeal. As far as the signs go, Nick mentioned those earlier. They seem to be pretty modest to me, and were traditionally, as I understand it, were there. I think you can make a case. We do, from time to time, consider anomalous buildings to contribute to the peculiar characteristics of a property, and this is certainly. The collection of garage bays and so forth certainly qualifies as anomalous in that particular case. And I'm also persuaded by the history of operation here. being inoffensive and in fact benefit the neighbors. So I'm inclined to support. Does anyone, would anyone like to make a motion either for or against?
Just before that occurs, this has been asked a million times, but just to confirm, Craig, we don't have to put any special conditions. That it's an inherent condition on the nature of what will happen that she testified about, right?
Correct. The application states that it's going to be a single stall garage, and it describes how it's going to operate. So if there is any significant change from that, they would be in possible violation of a conflict with the or the variance. Sorry.
But the record you have, you would have enough to enforce that based on what you have, right?
Correct. It would be in the minutes. It's also in the application.
Okay. I would move to approve all three of the variances.
Is there a second?
I'll second.
It's been moved and seconded. Mr. Winters made the motion. Mr. Wallner made the second. Is there any further discussion? All right, we'll start with Mr. Monahan.
Aye.
Ms. Spector Morgan.
Nay.
Mr. Wallner.
Aye.
Mr. Winters.
Aye.
And I also vote aye. With one dissenting vote, the variances are granted. And that concludes the regular agenda this evening. We have a motion to approve last month's minutes.
So moved.
Is there a second?
Second.
And Mr. Winters.
Aye.
Mr. Wallner.
Aye.
Ms. Spector Morgan.
Aye.
Mr. Monahan.
Aye.
And I also vote aye.
I think we
Fred,
can also,
is there anything? Yep.
yeah, July's minutes, I think, are in final form and can be considered tonight.
All right. Is there a motion to approve those?
So moved.
And a second.
Second.
Mr. Winters, vote.
Aye.
Mr. Wallner.
Aye.
Ms. Spector Morgan.
Aye.
Mr. Monahan.
Aye.
And I also vote aye. And that takes care of those minutes. Is there anything else before us, Craig?
Not that I have on my list.
All right, excellent. Thank you, everyone.
I got a question for Craig. How soon do the political signs have to come down?
As soon as you get out there and start.
Isn't it like
No, they should be coming down tomorrow. Anybody with signs that are out there in the public right of way should be out removing them now, or they're going to lose them.
Yeah, I think it's until next Friday. I think RSA says until next Friday. Is that correct?
No, because that RSA applies specifically to political signs, and where it's not content neutral, it's not constitutional.
Oh, touche.
Very interesting. Good night, everybody.
Yeah.
Good job, everyone.
Good night.
Thank you.